What's up, everybody? Welcome back in. I have been waiting for this motion from Sarah Boone's lawyer ever since he mentioned he thought this interrogation would be completely thrown out. We've all watched it together. I broke it down in multiple parts, an over 2 hour interrogation at the police station where Sarah Boone spilled her guts and, more importantly, said over and over again, this was an accident. This was not intentional, which we know now is a major problem for their new defense. Well, her lawyer has filed that exact motion to suppress all of the entirety of the 2 hour interview because her Miranda rights were not read to her correctly, is what he said. So we're going to dig into this. We're going to have a little lesson on Miranda, what it means, what it is, how it's violated, and whether or not that happened here to Sarah Boone. So get your questions ready, hit that like button, and make sure you subscribe. So the first thing that we should talk about with Miranda is, and we're going to talk a lot about it today, but lawyers file motions like this all the time in all sorts of different cases. Some of them are good, some of them are bad. But from a perspective of a last minute filing like this, and after the interaction between Mr. Owens and the judge at the last hearing, I had a certain expectation of this motion. And if you guys remember, a lot of you guys were asking, do you think her Miranda rights were read wrong? Were her rights violated? Is he going to win, et cetera, et cetera? And I said, let's hold, let's wait. Because I've argued this exact motion on both sides. I shouldn't say this exact motion, but this argument on both sides as a prosecutor and as a defense attorney. So I've done the research on both sides. And when I say on both sides, it's you got to know what the other side's going to argue, but you also got to know what the most helpful case law is in your case. And it's also a situation where even if it's not a perfect argument, you have to make it in order to preserve your client's rights. So when we talk about Miranda today, I'll give you some of that background that I remember from doing the research and these motions together. But I also want to put a disclaimer that if I was going to file this motion, I would do hours and hours of research, review the entirety of the interrogation again, especially the beginning, the body cam footage, put a bunch of sites in there, timestamps, link the video, make my arguments with case law about how this part of the video or this part of the statement or this part of Miranda fits in to this case law, and this is why her rights are violated, and this is what the case law says we have to do if her rights are violated. As we go through it today, it's going to be more focused on how Mr. Owens made this argument. Okay. And to start out, it's important to remember when Miranda is even necessary. Anytime you talk to a cop, Miranda is not necessary to be read to you. You don't have the same constitutional rights if you can just walk away, if the cops are not asking you questions. So the most important thing to start with is always a custodial interview or a custodial interrogation. And what does that mean? Well, being in custody can mean being in the back of a squad car, being at the police station, being in handcuffs. But generally speaking, it means that your freedom of movement is limited or blocked basically by law enforcement, and you don't feel like you can leave. Okay. And usually in Florida, and a lot of this is nuanced from state to state, and I'll talk mostly from where my knowledge for the most part is in Florida, but it's a reasonable person type of framework where if a reasonable person under the totality of the circumstances believes that they can't just leave or that the police are forcing them to be there, they're not free to terminate this discussion with law enforcement, then that would be considered a custodial discussion. And I put a couple of points down here, just some of the factors that I know we used to use when we argue these motions is the manner in which the police summon the suspect for questioning, the purpose, place, and manner of the interrogation, the extent to which a suspect is confronted with evidence of his or her guilt, whether or not a suspect is informed that he or she is free to leave the place of questioning. So do the cops say things like, you're free to leave, you can go anytime you want, you don't have to stay here? It's generally defined when a reasonable person does not feel free to leave. Okay? So that's the custodial part. The interrogation part is, are they asking you questions? Do they want answers? Are they talking about the case? Or is it just like, where did that person go? Running this way, that way. It's a question, but is that really an interrogation? Is that really an interview? And to dig into the nuance of this, you have to research the case law and compare and contrast cases that work the way your case is and the way you can differentiate cases that are not like your case. And you make those arguments. But if it's not a custodial interrogation or interview, you don't need Miranda. Guess what? None of that was argued in this case, basically. So from my perspective, I think everyone basically agrees that this was a custodial interrogation in which Miranda was necessary. So now let's get into the motion and read some of the arguments that Owens makes and how I feel about them if I was the judge, or how I would respond if I was the state. And I was hoping, I mentioned this off the top, so the judge said, Mr. Owens really wanted this, Miranda card and the policies and procedures from law enforcement. And he's like, I need this, judge. I'm going to file this motion. To suppress. It's so important. The judge is like, why do you need the card for that motion to suppress? Why do you need the policies and procedures for that motion to suppress? Isn't this based on the case law? Mr. Owens, what case law do you have that tells me we need that card? What case law do you have that tells me that there are these magic words that has to be in the policy and procedure book? And Mr. Owens said something to the effect of, well, judge, I'm not prepared for that right now, but I will do my research and file my motion, which is another reason why I wanted to wait until he filed this motion to see what arguments he made, to see what case law he found, because it's his case. He knows more about it. He'll do research. He'll spend a lot more time on it than I will. And I want to see what kind of arguments he comes up with. So here we go. Motion to suppress defendant's statements at OCSO. So specifically at the sheriff's office, which is also interesting. Comes now the defendant by and through the undersigned attorney, pursuant to Rule 3.190H, Florida Rules of Criminal Procedure, the 5th and 6th Amendments of the United States Constitution, Article 1, Section 9 of the Florida Constitution, and respectfully moves the court to suppress all statements made by the defendant during her interrogation at the Orange County Sheriff's Office in support thereof, states as follows. So it's not just part of the statements. It's not just certain use of the statements. It is all of the statements. The defendant, Sarah Boone, is charged by way of information of a single count of second-degree murder. On or about February 24, 2020, the defendant called 911 in response to finding her boyfriend, George Torres, deceased. Deputy Kayla Rodriguez of the Orange County Sheriff's Office arrived on scene with her body cam activated. Deputy Rodriguez spoke to the defendant and realized a death had occurred. Deputy Rodriguez advised her superiors and secured the scene. Sometime later, homicide investigators Chelsea Connolly, aka Chelsea Copsel, and Scott Lohan arrived. These two investigators would ultimately be responsible for this homicide investigation and were involved in the interrogation of the defendant at the OCSO the next day. The defendant was ordered to remain on scene while the OCSO conducted their investigation. The defendant stayed outside of her apartment for approximately 14 hours during this time. At some point, the defendant was asked to get into a vehicle with Detective Copsel and Detective Lohan. Once inside, Detective Copsel recorded an interrogation with the defendant after partially reading her Miranda Rights, omitting the final question. That's the important thing, and we're going to focus on that later. The defendant was advised this recorded interrogation was routine protocol, an official procedure for any death investigation. During the investigation, Detective Copsel asked to see the defendant's phone. The defendant complied and gave her phone to the detective. The defendant was asked to unlock her phone, and she complied with the demands of the lead investigator. After Detective Copsel had the defendant's phone for a period of time, she came back and told the defendant that she was taking the phone. Detective Kopsel asked the defendant to sign a form releasing it to OCSO for further investigation. The defendant acquiesced to authority and signed the form. So, one thing I'll point out here, just as we're through the first 8 paragraphs, is there have been cases where certain partial or imperfect Miranda rights were read, and the defendant either acquiesced or voluntarily, even without Miranda or before Miranda and after Miranda, voluntarily spoke with law enforcement, waived their Fifth Amendment right, to which that waiver was applied to future statements. And they look at the totality of the circumstances. And I think part of this analysis for the judge, and if I was the state to respond, that would be part of my analysis, that Sarah Boone voluntarily waived these rights over and over again. She did not feel coerced or forced to. She acquiesced at every turn and would continue. A lot of good questions coming in, and we will get to a lot of them. Paragraph 9. The defendant was told that one of the detectives would return her phone to the defendant at her apartment in Winter Park the following afternoon. Later that evening, the defendant moved to her husband's home, Brian Boone, for the night. Using her ex-husband's phone, the defendant called lead detective Chelsea Kopsel to express her concern that Detective Kopsel was not being truthful about law enforcement's motives as it relates to the defendant. So we didn't hear this conversation, but it sounds like Sarah Boone said, "I don't believe you that you're not looking into me," or something to that effect. The defendant told the detectives that she believed they were trying to trick her. And we know, as annoying and horrible as it is, law enforcement does not have to be perfectly honest as they're doing an interrogation or an investigation. The next day, Friday, February 25th, 2020, the defendant arrived at the OCSO to retrieve her phone and had questions about this tragic event. So Sarah Boone had questions for law enforcement. While still under the impression that she was retrieving her phone, Detective Lowen led the defendant upstairs into an interrogation room. A custodial interrogation ensued. Immediately after the interrogation, the defendant was arrested and charged with the offense above. So we don't see any case law to this point. We don't see any argument from Mr. Owens proving that this was a custodial interrogation. I think the reason for that is he thinks it's obvious and that the state won't argue it's not a custodial interrogation. I still would have done the analysis, done the case law. You could have done it in 2 paragraphs. He did not. I do not think that's going to be a killer for this motion. I don't think that's going to be a reason he loses this motion because he didn't do that analysis here. Scott said, "Let's keep it simple. There's no circumstances in which you should ever speak to the police, not without speaking to a lawyer first." I agree with you there, Scott M. Iris, been watching for a while. Thank you for your unbiased views and knowledge of this case. You're welcome, Iris. Thank you for being here and joining us. Let's take a look at specifically Mr. Owens' arguments as to why these statements should be suppressed. This approximate 2-hour interrogation was recorded, and most of us have watched it together. The initial dialogue between Detective Kopsel and the defendant, Sarah Boone. So he is going to quote parts of this interrogation. Something I would have done to potentially entice the judge to watch this part of the interrogation is maybe all of this, judge, is taken from time block 10 minutes to 20 minutes, whatever it may be, for the beginning of the interaction, and of course, the partial Miranda warnings read to Sarah Boone. I would have given a timestamp. I would have given a link. It's not inappropriate at all for Mr. Owens to quote, "Detective, I'm going to have you sit in the green chair. Detective, appreciate you coming in. Sarah Boone, yes, ma'am. And I want to ask about these whenever you have a moment," referring to her written notes with questions. And you can imagine Sarah Boone showing up with written notes of questions. But she's entitled to ask questions. That's her right. Would I have done it in this situation? No. I'm not going back to the police station unless they call me in, unless they force me in. I'm not saying any words to them, including questions, because those questions, by the way, folks, can be used against you. But this is also a good example of a potential spot where Miranda is not necessary. If Sarah Boone called, she wanted to come in to get her cell phone. She sits down of her own volition and she speaks and asks questions to the cops about this interrogation. Let's say that's what happened. And she said, well, what did you find when you found his body? Well, what did you find on my phone? Well, what did you think about the fact that the suitcase was upside down? What did you think about the fact that the suitcase ended up downstairs? If she asks those kinds of questions, that would not be considered a custodial interview or interrogation by law enforcement because Sarah Boone is the one asking the questions. So there's a good argument to be made that questions asked by Sarah Boone when she voluntarily came to the police station is not a custodial interview if it was just that. But also, if you're the state and you don't have that scenario, obviously, because the cops ask her a lot of questions and it's definitely a custodial interview. But I think the overall mindset as far as tricking and coercion, and, we'll talk a little bit about ways you can make those arguments as a defense. But Sarah Boone wanted to have a conversation and dialogue with law enforcement. I think you can make that argument. Sussex Sandra said, partial Miranda rights, what impact would omitting the last question be an issue? Great question, and we're going to answer that as we go. Buzzman Jr. Peter, will the judge have to watch the interrogation now? Thank you for all the work you're putting in. If nobody asks him to, he doesn't have to. I would have put a block in with the link because then that becomes part of my motion that he needs to review prior to making his decision. I'm not sure Mr. Owens put that onus on the judge with this motion. At least not yet. And we'll keep reading to see what else we can find. Detective, sure. Detective, so obviously he received his autopsy. Detective, so I'm going to read you your rights again because we have to talk about that. And Mr. Owens has a problem with the verbiage have to, as if she's being forced to. Okay? And that could be important, and we'll talk about arguments you can make. Detective, and we're not done talking about the incident. We just have to do it. Just like we did yesterday. By the way, read your rights again, referencing yesterday when her rights were read to her. Sarah Boone said, just like we did yesterday, normal protocol, detective, just like we did yesterday. Remember I read you your rights? Yeah, it's the exact same thing, but since I'm asking you follow-up questions, I need to read them to you, okay? So I do have some questions about Owens' strategy here. He's not asking to strike anything prior. He's not asking to strike any of the statements made in the prior interrogation where she read her rights. Yet he says earlier in the motion, she omitted the last question there too. So why not try to suppress those? I don't know. I don't know what the strategy is in that. I don't know. But she does, both of them reference yesterday, how Sarah Boone, understands that's how it was yesterday. She said, remember I read your rights, I'm going to do the same exact thing. Then here's the important part that's in bold. So you have the right to remain silent, okay? So when we make arguments as defense attorneys, and law enforcement says stuff like, we have to talk about it, we just have to do it. Are they insinuating, coercing, forcing the defendant to talk? Are they making it seem like the defendant has to talk so that they don't even listen to the Miranda warnings and it doesn't matter? And there are situations where this can be a winning argument. But let's read the Miranda warnings. And this is something that even the defense is admitting was read to Sarah Boone or told to Sarah Boone. You have the right to remain silent. So even after saying you have to talk or we have to do it, she's being informed of her right to remain silent. Anything you say may be used against you in court. You have the right to talk to a lawyer, and here's another big one, before and during questioning without charge. A lot of aspects that are important that must be read in the Miranda warnings. And now's probably as good a time as ever. Actually, yeah. Now's as good a time as ever to kind of throw in some of the arguments that I think the state's going to make. From my perspective, whenever I've done the research, there's no magic words. Now, you can make some of these arguments in front of a jury. You can make it look like she was coerced. But legally speaking, when trying to get statements suppressed, you have to meet the legal standard. And the legal standard for Miranda is you have to convey, as a law enforcement officer, a certain amount of information to a suspect so that they fully understand their rights and waive them before speaking to you. There are not magic words. You do not have to read a card verbatim, although in order to get past a lot of these arguments, most law enforcement agencies have a card to dummy proof it and just be like, don't even think, Mr. or Mrs. Officer, just read the card. And if they say yes at the end and they still want to talk to you, then you can ask them your questions. So whenever they don't read their card, it's kind of annoying. It's like, that's why it's there. Come on. Doesn't seem like she read her card fully, but what is the important information to give in Miranda warnings? The most important information that must be conveyed is that a suspect knows they have rights. They have rights to remain silent. They have rights to an attorney. They have rights to know that anything they say can and will be used against you. And they have to make a knowing and intelligent waiver of those rights. How do you know it's knowing and intelligent? Well, you can ask them. You can have them sign something. You can over-explain. But there are some nuances with each one of these rights. Like, for an example, an attorney. It's not just that you have the right to an attorney. Because there have been cases that have been overturned and statements suppressed because and I think the Chad Doerman, I think that's that case, but I can't remember. It's a case that's been on YouTube, I believe, had statements or even confessions suppressed because they didn't let the criminal defendant or the suspect know that they could talk to the lawyer before or even during this interview or interrogation, and that they could stop it at any time to talk to a lawyer. So that's very important information you have to convey to the suspect. But not just that. What else is tough about a lawyer? Well, a lot of people can't afford a lawyer. So they may think, yeah, right. If I could pay for a lawyer, sure, I'd love to talk to one, but I can't pay for one, so I'll sure answer your questions. I'm screwed. Well, no. You have to let them know that a lawyer would be appointed to them, that a lawyer could help them at no charge. That's why we have the public defender's office, to help people who cannot afford a lawyer even before they've been charged, even in custodial interviews. And then, of course, ask them and try to make sure as much as you can that they understand the rights that they are waiving. That is basically, with, again, a lot more nuance than we have time to get into today. A lot of different factual scenarios and totality of the circumstances has had me making different arguments from both sides. But generally speaking, that is what has to be conveyed to a criminal defendant in a custodial interview in order to not violate their rights. So with that in mind, let's read through what was read to Sarah Boone and then talk about some of the arguments defense counsel makes. You have the right to remain silent. Anything you say may be used against you in court. You have a right to talk to a lawyer before and during questioning without charge. And then a step further. If you cannot afford a lawyer and want one, one can be provided to you before questioning without charge. So that's one of the more common mistakes, frankly. That is one of the more common mistakes. That they forget to say before, during, without charge, things like that. And then this final statement, I think, is good. Has anyone threatened you or promised you anything to get you to talk to me? Sarah Boone says no. So we jump back up here real quick, and we're going to read more of Owen's arguments, but he even said this in court, so we knew this was coming, the have to talk. We have to talk about it. We just have to do it. And this is where, if I'm the judge, I am going to watch the video, because thank God we have video. And if we have it, we should use it to make sure justice prevails and to make sure we understand what the dynamics were like. Was it a dark room with the light shining in their face and them saying, we have to talk to you no matter what? Or was it something like, hey, we've got to talk. We have to talk. We just have to talk about this. We have to do it. How was it? That context matters. I would argue from watching the interview that it was the latter. I don't think these detectives are perfect, right? We picked apart some of the stuff they did. Sunny Side Up said splitting hairs. That's like half of law, right? Splitting hairs. Sometimes it's a winning argument. So, so when she reads the question, or when she says the statement, has anyone threatened you or promised you anything to get you to talk to me? These would be considered threats, according to James Owens, I believe. So if she threatened her and then 1 minute later was like, has anybody threatened you? And Sarah Boone says no, how far are we going to go to say that Sarah Boone was acting as a reasonable person and didn't feel threatened at that time? What else can you do as law enforcement? Does case law say if they use the word have, must, or shall, that it's over and you can't ask them any more questions now? No, it's not what it says. Especially if you go a step further and ask that type of question. AF said, does anyone know if this motion will be addressed during tomorrow's hearing? Also, what's the likelihood that this will be granted? So I don't know. I hope it's addressed tomorrow, because the longer anything gets pushed or waits, the less likely we go to trial on October 7th. And what's the likelihood of this being granted? I will answer that at the end. John said, there are many instances where the person that's detained plainly refuses to answer the Miranda questions. How is that any different than omitting the last sentence of the statement? If they refuse to admit, they're invoking their right, which is totally fine. This is a situation where they are saying, oh, okay, I think I get what you're saying. Okay, I'm going to hold this question. And Azam, I'm going to hold yours as well, because I think it'll go better a little later in the motion. Okay, so did anybody threaten you to talk to me? No. And then, remember, folks, it has to be a knowing and intelligent waiver, right? Do you understand what I just read to you? And Sarah Boone unequivocally says yes. So, what is she saying yes to? And honestly, this may seem laborious, but this is the analysis we go through as lawyers to try and figure out if rights were violated and what arguments we can make. But we're going to work backwards now. Do you understand what I just read to you? So the preceding paragraph, do you understand that? Yes. So what does she understand? She understands she has a right to remain silent. She understands anything she says can be used against her. She understands she has a right to talk to a lawyer before and during questioning without charge. If she can't afford a lawyer, one will be provided for her. So she understands all that. Yes, I understand all that. Perfect, okay. And then right into questioning. Is it knowing and intelligent? I would argue yes. Is it a waiver? That's the big question. Detective. So this morning, we went to his autopsy and we were informed of some injuries he had by the doctor. Defendant, where? So he's got scratch marks on his back. Okay, it's kind of interesting because these aren't even questions yet, but this is what he puts in there to just say, boom, they go right into the custodial interrogation that lasts for 2 hours. The interrogation continued for approximately 2 hours. At the end, while still in the interrogation room, the defendant was placed in handcuffs and arrested, much to her dismay and shock. The detectives read the defendant her Miranda rights directly from the printed card of the OCSO. The detectives omitted the final question printed on the standardized Miranda card of the Orange County Sheriff's Office. The detective omitted the same Miranda rights questions that she omitted the day before. So that's a problem with this officer, and I will say that's frustrating. This officer should get a talking to and maybe take a course or a reminder that you should read all the questions on the Miranda card. That's why they're there. But did she violate her rights? And first, Azam asked, isn't that a complete Miranda right? Well, Azam, here is the complete Miranda right question that she missed. Having these rights in mind, do you wish to talk to us now? The defense has yet to receive a true and accurate copy of the Miranda rights card from the Orange County Sheriff's Office, but upon information and belief, they think it looks something like this. Miranda warning. You have the right to remain silent. Anything you say can and will be used against you in a court of law, which, by the way, is also not how she read it. Anything you say may be used against you in court. I like this better. Can and will be used against you. So again, imperfect, not the magic words, but does it still give the full explanation? You have the right to talk to a lawyer and have him present with you while you are being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you before any questioning if you wish. You can decide at any moment to exercise these rights and not answer any questions or make any statements. So I believe this one was left out as well. Correct. And instead, she added this in, the threatening part, which I'm glad she put the threatening part as far as Sarah Boone's rights being intact, because I want to make sure Sarah Boone did not feel threatened based on the have to talk and have to do it. And that's why I think this question was good and Sarah Boone understood it. And then lastly, the waiver. Okay. Do you understand each of these rights? I have explained to you. Having these rights in your mind, do you wish to talk to us now? And now back to John's questions. A lot of time people don't understand or don't answer that they do understand these rights. I think that's what he meant. And in that situation, the cops got to make a judgment call. Do you go forward, even though they won't understand? Are they doing things or saying things that make you think they understand? Or better safe than sorry, and you just don't ask them any more questions because it's not a knowing and intelligent waiver. I would go with the latter because I don't want to violate people's rights. Most cops continue to ask questions and they think, well, if it gets suppressed later, then it gets suppressed later. But that's a good question. Kathy, cool. I just realized that if you tip the N over in Sarah's last name, you get booze. Good one. Good one. Reese's mom, I've seen cases where LE reads each part of the Miranda and had the person initial each one after reading it. I love it. If I was a cop, that's what I would do. I would do everything possible. I don't care how long it takes to make sure they understand and document they understand, whether or not they change their mind later. But I love when cops go above and beyond. Based on all the circumstances surrounding this interrogation, the defendant's statement was coerced and not freely and voluntarily given. The defendant did not freely and knowingly waive her rights under Miranda. As such, the entire 2 hours of investigation should be suppressed. Wherefore, the defendant requests that pursuant to Rule 3.190H, Florida Rules of Criminal Procedure, 5th and 6th Amendment, U.S. Constitution, Article 1, Section 9 of Florida Constitution, respectfully move the court to suppress the oral statements made by the defendant during her interrogation at the Orange County Sheriff's Office on February 25th, 2020. Filed yesterday. That's it, folks. Not a single case cited. No factual scenario from a similar case in Florida to say, look, judge, in this case, they suppressed these statements. In this case, when they didn't read the words right on the card, they suppressed these statements. At the very least, give me a case that says, if you don't ask that last question, it is not a knowing and voluntary waiver. If that case existed, it would be very helpful to Mr. Owens and Ms. Boone. Why is there no case law research in here? I think it's going to be up to the judge's discretion at the end of the day to make the call. But another thing I didn't love from James Owens here is, why didn't he make an argument about the have to? He didn't even repeat it and say it was coerced because the detective said Sarah Boone has to talk to her and they have to do this now. Why didn't he make that argument? So I think my analysis of this is, I hate that the lawyers did not read the last question. I hate that they didn't read verbatim off of the card. Now, their card could be a little different than this because he did say he doesn't have their exact card. So that's a caveat we have to throw in there, that maybe the verbiage on their card is a little bit different, again, because there's not the magic words. My voice is still recovering from pool basketball this weekend. But I wish the cops would have done it differently. I wish they would have done it better. But even in their poor recitation of the Miranda rights, did they check all the boxes? And it's a resounding yes for me to everything except for the waiver part. But the context of, do you understand all these rights? Yes. and then following up with answering the questions and speaking to law enforcement and asking them some questions of your own and bringing questions of your own there to talk to them and driving over there of your own volition and giving them your phone and your passcode and having this all on camera, frankly, to me, if I was the judge, watching this and judging based off the totality of the circumstances, which frankly, James Owen said, based on all the circumstances, it was coerced and that's it. He just makes a conclusory statement, frankly, and not given freely and voluntarily. I think that's totally false. Like, I think that's one of those situations where somebody's telling you, this is clearly my right hand. You might not be able to tell because we're mirrored here, but me saying this is my left hand. It's like, I'm looking at it. It's your right hand, dude. You can say it's your left hand all you want, but if you're going to give me it to look at, maybe that's why he didn't link it. Maybe he's smarter than me. Maybe he didn't link the interrogation because he doesn't want the judge to watch it. I don't know. But from my perspective, I think the cops did barely enough here, but enough to where the judge is not going to suppress these statements. If I was going to give a percentage chance that Sarah Boone wins and has these statements suppressed, I would put it in the 1 to 5% category because I am never 100% positive about anything because it's the law. And we'll see the state's response. I expect it to be the no magic words. They checked all the boxes, totality of the circumstances. She came there freely and voluntarily. They did tell her about all the rights that were important. It was a custodial interview, but her rights were not violated because Miranda was read in enough of its entirety. And nowhere says you have to ask a magic question about, do you waive these rights? That's what I expect the state to argue. I expect the state to have some case law in there, I would hope. And I think whenever I see a motion like this, and I'm not hammering James Owens, that dude is probably doing so much. I understand he's probably so busy packing all this in, probably trying to get this filed before the hearing tomorrow. But if I ever see a motion filed against me with not a lick of case law in it and just conclusory statements, and my response, you better believe there's going to be a ton of case law, even if it's general case law about Miranda. And I will make a comment about how that's not a legal argument. That's a conclusory statement with no even factual or legal argument to back it up. He just put facts on a piece of paper and said, clearly, totality of circumstances, it's coerced and not freely and voluntarily given. So that's what I would argue in response to this. And if I was the state, that's what it would look like. Do you think it's coerced, Peter? No, Azam, I don't. And as much as I wish law enforcement would have done things differently, I think Sarah Boone knew what she was doing and thought she was going to talk her way out of it. Dylan, I wish George Torres with a Z was the victim in this case. Look him up and you will agree. D-Trug, in my opinion, it's not perfect, but doesn't rise to a violation of her rights. Yeah, let me know what you guys think. After my very basic level, probably not so well explained to you about what Miranda is and what has to be done. After reading this and knowing that it was not read verbatim, it was not perfect, they did not ask that last question. What do you guys think? Do you think her rights were violated? Because we're big proponents of protecting people's rights. And if her rights were violated, I want all of these statements suppressed. If you were the judge and you believe her rights were violated. Reese's mom said, what was left out in Doberman? I think it was that, and again, I have a vague memory of this. I think it was that they didn't tell him he could talk to an attorney before or during the interview. Something like that. They told him he could have an attorney, but not before or during the questions. How often are the Miranda rights read verbatim? Is this a rare occurrence? I'll leave out the last question. So I would say, I don't know if I would say either is rare or happens a lot. I think a lot of cops read it verbatim off the card. That's why they have it. They'll pull it out of their thing. They make it part of their process, which I think is best practices, but a lot don't, especially seasoned cops. But I will say, as often as I've seen officers not read it verbatim, they make every mistake in the book. And just like a lot of other things in lawsuits and things that stem from mistakes people make, lawyers make a big deal and make a mountain out of every single little thing that is left out. So if there is something that is left out, a lawyer will find it. They will explain why it screwed with their client and messed up their client's rights. For example, you leave out this question, I'm going to say it was knowing and intelligent, but it was not a waiver. And I would have put a lot of research in this motion about what a waiver is and why a waiver is important. And you cannot get an assumed waiver for X, Y, and Z. I would have at least tried to make those arguments. And then maybe forgetting this question does become case law and precedent that in Florida, you don't ask this question, you don't get a waiver. You did not get a knowing and intelligent waiver. But again, not knowing you could have a lawyer paid for you. The reason that became precedent in Florida is because it happened, a lawyer argued it, and a judge agreed with them. And it was probably appealed up and confirmed. Same thing with a lawyer during the interview and after the interview and before the interview. Same thing with you have the right to remain silent. Same thing with telling them that these words can and will be used against them. If I was James Owens as well, based on the quotes he gave, because this was so bare bones anyways, I would have pointed out everything she said that was different. Because basically every line she read was a little bit different than what's on the card. And I would say there's a reason for the cards, Judge. It's not a bright line rule. It's not magic words, but there's a reason for the card. And she totally disregarded the card, read it her own way after saying we have to talk. And so the way that she did this with Sarah Boone was coercive. Still don't think you'd win, but I think it's a better argument than what we got here. Megan, how can they say people aren't cooperating when they ask for an attorney? Isn't that a violation of their rights? Yes. You cannot use the fact that somebody asked for an attorney against them. Fletcher Boy, with the new defense strategy, could the state amend or even refile first-degree intentional? It's an interesting thought. I don't think there's any real reason to. But like we said when we talked about it before, and by the way, Monday's podcast, Whitney is coming on again to talk Sarah Boone. And it's feisty. It's great to have an outsider's perspective on how they look at this case. Very different than a lawyer's perspective, much more like all of your perspectives. So make sure you guys subscribe, hit the reminder bell, and watch the podcast. It's a fun format. We'll see how it does. If you guys like it, we'll keep doing it. If you guys don't care for it, just like any other content, it'll go away into oblivion. She said, when you all go through my phone. If she is found, she thought the phone was going to prove her innocence. If she's found guilty, does she get any compensation from the time spent in jail? So no, you don't automatically, if she's found not guilty, you don't automatically get money if you were arrested and end up not guilty. Now, if there was some kind of fraud or some kind of misconduct by law enforcement or prosecutors, then potentially, yes, you could sue them for that and collect for your time in jail as part of the damages. But there's a lot of immunity in arresting people when you have probable cause. That's the point of the probable cause standard. If there is probable cause, you're allowed to arrest them, even if they're not guilty beyond a reasonable doubt, because those are two different standards. And if they rise to the level of probable cause, but not beyond a reasonable doubt, you can't sue for being put in jail. Thank you, Azam, and everybody, Charlie and everybody else that gifted memberships. Jackie P. We're supposed to have our members only live tomorrow. But in case you're not following the news in Florida, Christy, stay safe over near their coast during the storm. Thank you, Christy and Anya. Peter, are you safe from the hurricane? So it looks like we're in the cone of the hurricane, but we will be all ready. It's supposed to hit tomorrow. So we'll see. Maybe no video tomorrow, maybe a live from my porch with a hurricane behind me like we've done in the past. We are all prepped and ready. We've got hurricane windows, roof clips, doors, impact everything. We pull all of our furniture in, secure everything that might be loose. So all that's already been in the works for preparation, and I will finish doing that tonight. So I appreciate you guys so much. Lilo said, the 7M, love the 7M episode you did. So yeah, in case any of you guys watched that Netflix documentary, Dancing for the Devil, with the 7M alleged cult stuff, Whitney was engrossed in it. And now so many people have watched it and texted me about it or emailed in about it. If you have watched that, or even if you haven't and you're interested in it or interested in cults and how the law potentially protects cults, check out our podcast from Monday, a couple days ago. Please go check it out. Help support that podcast and the time Whitney's putting into it, which has been awesome. And our other guests that we have coming in the future as well. There are some that I absolutely know you're going to love, and some that you may have come to this channel from. Yes, Azam, we are big fans of justice. Charlie, for my 1-year membership, celebrating with membership gifts, please stay a year so we can hit a jury of 500,000. Yes. By the end of the year, we're trying to get to 500,000 subscribers. If you subscribe, you will help with that. Charlie's bringing 5 more new members to our members only video either tomorrow or if the hurricane hits tomorrow, but it's not that bad, maybe Friday, but sometime very soon, we're going to be talking all sorts of fun things. So I appreciate you guys so much for joining me. I appreciate you coming on. Continue to let me know if things come out in this case. I love following this case. It is in Florida. It's a case I'm planning on attending part of the trial. I'm very interested in it. A lot of little nuances going on that make it entertaining and enjoyable to follow and discuss, especially because of you guys. So let me know this case. If there's any other cases you guys are watching or interested in, let me know about that as well. Nicole said, my brother and sister-in-law live in Bradenton, and this is their first hurricane. I hope you and your family stay safe through it. Thank you for all your videos. Yes, Nicole. First one, I'll be praying that they get through it and everybody in Florida gets through it unharmed. And it's just a lot of rain that we deal with as it goes through. Kelly D, love the new podcast. Thank you so much, Kelly D. Yeah, tell your friends. Tell your friends about the new podcast. Come out, support, listen to it, like it. Go give it a review on Spotify or Apple or wherever you listen to podcasts. If you give it a watch on YouTube, that's great too. Double duty is always helpful. But you guys are the best. I appreciate you so much for how do I find the podcast? Nona Brown said, Kelsey, why don't you drop a link in the chat box to the podcast on YouTube? So you can find it on Apple, iTunes, Spotify, whatever, but you can also find it on YouTube. Kelsey's going to drop the link in the chat here now. So that anybody that wants to go directly there can just click the link. So I'm going to play the outro here. The link will be in the chat to our latest podcast episode. Thank you, Azam. There is the link. Thank you, Azam, for sending us out with a super sticker. I will put this on the screen now as we head out for anybody that wants to check it out. All right. You guys are the best. If you haven't hit the like button, hit it now. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.